It's been a big day for the LGBTQI community in India, or the queer community, but it's been a disappointing day. The big judgment of the five-judge constitutional bench of our Supreme Court examining the matter on whether or not the queer community should be given the legal right to recognized marriages. That judgment came in today, and by a majority judgment of 3-2, the court has decided that no, this is not a matter for the court to decide. This is a matter for the legislature, for parliament to decide. In fact, we have senior advocate of the Supreme Court, Sanjay Hegde, joining us in a bit to sort of break down that, that whole point of view from the legality of this judgment and to tell us what happens going forward. But let me just tell you right now as to what the judgment has been. So the first point of whether or not the queer community has the right, an unquestioned right to marry, the answer is no. The court has decided that that is really beyond the scope of interpreting the law, which is the court's job. It is really changing the law, which should happen in parliament or in state legislature. The second question of whether or not the Special Marriage Act, which is when two Indians who are from different religions marry each other, or the Foreign Marriage Act, which is when an Indian marries a foreigner, whether both of these acts can be changed to not just specify man and woman, but any two consenting adults. Again, here the court's answer has been no, because it's not within the purview of interpreting the law, but it's actually changing the law, which should happen in parliament. The court has also specified that transgender people who are in heterosexual relationships, so a trans woman marrying a man or a trans man marrying a woman, they can continue to get married under the existing laws, but this was already the case. This is not new as of today. And the court has asked the government to set up a committee that will examine the rights and the benefits that can be given to couples who are in queer relationships, who right now don't have the ability to get married. So that committee will examine matters like bank accounts, insurance policies, medical consent, last rights, inheritance, nominations, all of those things, and give a report to government, and then the government can choose what it wants to implement out of that report. The other big question was the question of adoption. Now, it did seem like the first two judges who gave their responses, which was the Chief Justice Chandrachud and Justice Kaul, seem to be leaning towards the idea that queer couples should be allowed to adopt jointly, because currently they are allowed, according to the laws, to adopt as single people, but not jointly. But again, the majority judgment of the other three judges, Justice Bhatt, Justice Kohli, and Justice Narasimha, have decided that no, that is not again something that the court wants to change at this point, that it will remain as it is, which is single people can adopt, but as a couple, queer couples cannot jointly adopt children. So this is where it stands right now. And really the questions to ask at this point is what happens going forward? Has the court given us a structure for any sort of civil union? Is there enough room here for more litigation in smaller courts to change things? And the Chief Justice giving clear instructions to the police, for example, saying that same-sex couples or queer couples are not to be harassed, that when family members file complaints against them to keep them apart, the police should in fact apply some preliminary investigation to see if that's the case and not bother the couple in question. Also giving instructions to government to end discrimination against queer people, to create some sort of education, to create safe houses, hotlines, mental health support for the community. These instructions, of course, sort of create a framework of what the community can expect from government and from police going forward. But in terms of marriage and adoption, the answer as of today is no. And to help us, like I said, sort of break this down and understand it further, Senior Advocate of the Supreme Court, Sanjay Hegde, is joining us right now to sort of interpret the interpretation of the Supreme Court. Mr. Hegde, thank you so much for making time today on a very important day to sort of break this down for us.
Thank you,
Initially,
Faye,
it
for
did
having me.
seem Thank you. Initially, it did seem when the Chief Justice was reading out, his note, his judgment, that it did seem really positive. But towards the end, we realized that that was actually a dissenting note, and there were three judges who disagreed with that point of view. But the big takeaway was the Supreme Court saying that, you know what, this is not our job to make this change in the law. That is for Parliament to do, or that is for the legislature to do.
Could you help us understand that? Because technically, even based on what the Chief Justice said, he said changes we've seen in marriage, widow remarriage, intercaste, interreligious marriage, child marriage, all of this has come because laws have been changed. So, at this rate, do we have to just wait for Parliament to make that change? You,
See, after today's judgment, unless it gets referred to a larger bench and there is a relook, that is the position in law. The Supreme Court, by a 3-2 majority, said that, look, under the garb of interpretation, we cannot legislate. Yes, there have been changes in the law, as the Chief Justice has said, but all those changes also came from the primary source of law, which is legislation. They did not necessarily come through a process of interpretation. And the Supreme Court is very conscious of the fact that it is an unelected body. Nobody elected the Chief Justice or the other judges of the Supreme Court. They have a constitutional function of interpreting the law as has been legislated by Parliament. If it is interpretation for of one section, and the question is whether a broader interpretation or a narrower interpretation would suffice, that was possible. But uh, interpreting just the section to allow gay marriage would also have consequences in many other legislations, including adoption, including succession. And ultimately, it was something which the court said is best left to Parliament. So that's where we stand. Uh, the the Supreme Court interpreted 377 of the IPC in a manner as to not penalize consensual homosexual sex. But keeping it out of the criminal fold was a matter of interpretation. Now, to specifically say that uh, homosexual marriage or a same sex marriage is the same thing as any other marriage,
yeah.
that would be that would require an act of parliament, because any kind of formulation that the court came up with would almost invariably reek of legislation.
Mr. Ira, I do want to ask you about the idea of a union, and this was a question a lot of people had after hearing out the judgment, because the judges kept referring to a non-heterosexual or a queer relationship as a union, saying they're free to enter this union. Now, overseas, there's something called a civil union, which couples can enter, which is a non-religious, or what we call a court marriage. The judges have not given us any sort of legal structure for that sort of union, have they? So right now, whatever we have is what already exists, which is a live-in relationship.
Yes, see, you can have any relationship. It could be a one night stand, it could be a long term relationship. But to give it the same status of a marriage where the spouse inherits the property rights, or the spouse can take a call in respect of medical decisions. For instance, somebody is required to give consent for a surgery. Now, in the absence of any recognition in law for these relationships, all those avenues are not available to a homosexual couple. The two judges seem to think that a kind of civil relationship could be allowed, but even the contours of that would have to be decided by a committee which would be headed by the cabinet secretary. They uh, base themselves on a statement made by the Solicitor General for the Union of India that a committee would be constituted and the cabinet secretary would uh, have consultations with all players and then come up with a scheme. So the minorities sanctified something close to a civil relationship, subject, of course, to what the committee finally decided. But the majority said that even the formulation of a civil relationship was also essentially a piece of work for the legislatures, and that the courts could not go and construct one.
The same thing, on adoption rights. Again, in the beginning, it did seem from the Chief Justice, the Chief Justice said very clearly, he argued against the CARA regulations, which are the adoption regulations in India. He said if a single person is allowed to adopt, why not allow an unmarried couple to adopt, which an unmarried couple would then include all queer couples as well. But it seems also that the three, the majority decision of the three judges went against that. So as of now, Mr. Hegde, adoption not allowed either, right?
No, each of the partners could possibly individually adopt a child, but the child would be a, adopted only by that partner and not by the relationship. So, in case the relationship breaks, there is no question as to who the child goes with. Otherwise, in a heterosexual marriage, supposing there are divorce proceedings, there are also proceedings for custody of the children.
Yes.
So those questions also would have otherwise to have been decided. But now with the current regime, two people in a same-sex relationship could individually adopt. So whoever has adopted that particular kid, I know same-sex couples who have adopted more than one child. But maybe one child is adopted to one partner, the other child to the other partner, though they are brought up together. In the event that parties go their own way, the child would follow the respective adoptive parent.
Mr. Hegde, the Chief Justice also in the beginning talked about how Article 15(1), which is the law against discrimination in India, saying no one should be discriminated against based on their religion, based on their caste, will include from now on sexual orientation as well. Now,
Yes, you cannot be discriminated on account of your gender. The word gender was interpreted to include sexual orientation.
so as of now, does our Article 15(1) stand changed? Will it now also say sexual orientation, or gender has
No,
been
see, listen,
interpreted for us as yes?
listen. No court judgment can change even one single line of legislation. It can only interpret it. So here again, uh, the Chief Justice was giving his interpretation about all the factors that persuaded him to rule in favor of setting up something akin to a civil union. So this is part of the reasoning of the opinion of the Chief Justice. That part of the opinion, we do not see that there is any specific concurrence by the majority, and in the absence of any signed common order signed by all judges of the bench, it is difficult to postulate that something has been authoritatively interpreted one way or the other.
Okay. Okay. And do you think that at this point, the Chief Justice also gave a lot of directions to government, directions to the police, and asked for a committee to be formed that will, consider certain points of rights and benefits to queer couples? How much of that is the government bound to follow?
See, the government has made its statement in court. The committee was not something which was ordered by the court. The government made a statement and it will be bound by its statement in court. And as to the terms of reference, no doubt the committee will rely on what is stated in the various judgments. Even the majority has relied on the fact that the government has has given powers to a committee to decide certain things, and so the only difference is of nuance between the two. That the majority would not bind down the committee to any explicit formulation, whereas the minority opinions seem to give it a particular mandate.
And it also seems, let's assume the committee does deliberate and come back with a report. Is the government and the state governments bound to take all of those suggestions, or does it still depend on the discretion of the government as to what suggestions from the report it wants to adopt?
Well, the governments would not be bound by the decision of a committee. It's not as if the Supreme Court has pre-approved anything that the committee comes up with. So if the committee comes up with the suggestions and which are workable, the government accepts it. Then, if in the acceptance there are problems or there are constitutional infirmities, the Supreme Court may again look at the exercise if it is challenged.
And Mr. Hegde, in your opinion, here, there is no time frame for this committee. There's no sort of structure as to by when all of this needs to be implemented. Um, how often does something like this actually fructify?
See, ultimately, when you leave it to the legislature, you also are leaving it to the wisdom of the people, the kind of legislators that they vote for. If uh, people of a same sex orientation, as well as their families, exert enough pressure and at the hustings, and they matter, then obviously the government would be more minded to see that if the committee came up with some kind of glasnost or perestroika in these matters, that it would possibly accept it. But otherwise, as they say, a committee is a set of people who individually can decide nothing, but can collectively decide that nothing can be done. That is often the fate of many committees. And also, I doubt that any committee can come up with any report during the working lifetime of this present government. It will all possibly be a post 2024 exercise. Of course, there may be votes for politicians who promise that in 2020, after 2024, they will get cracking on it and that they will lead to an expansion of these rights.
Mr. Hegde, in terms of further, cases that can be brought to maybe demand more of these rights again, has this judgment left anything on the table for someone who wants to, A, come back and appeal, or take smaller portions of it to smaller courts? What's the way forward for the petitioners?
No, this set of petitioners have fought all the way to a five-judge bench, and it's very rare that a five-judge bench goes to a larger bench of seven judges. So now, within the logic of what the majority has held, and even the majority does not say that these rights cannot be granted. All that the majority says is that it can't be granted by a process of judicial interpretation. They can only be granted by the legislature. So, pushing certain demands, specific demands, without a broad overarching petition, that is quite possible. Now, if, for instance, somebody in a committed gay relationship had an issue with regard to granting consent for surgery or wanting his or her partner to be able to grant consent for the surgery, that as an independent case maybe could be agitated if there was a case which rested on actual facts. Because when you ask for a prescriptive norm to be applied across the board, that is definitely a legislative exercise. But if in a particular fact situation you assert a right and take it to court and say that this right should logically belong to me, it may well be that in that case the court can rule in your favor. And that becomes a precedent for others.
I was having a conversation with Ashok Rao Kavi a little while ago when the judgment was coming in, and he said the only thing left to do is for people who've been in long-term relationships to take their rent agreements and go to a court and attempt to register an agreement of that relationship in some form of civil union. and thereby start a case that will eventually ask for a civil union. Do you see that as a possibility?
Yes, see, that is how a lot of that is how legal systems operate. You start from the court of lowest instance. It is not that you make a jump right to the Supreme Court and
Yes.
I ask for one answer that fits all. So let's take that example. There is nothing which prevents two people from registering a rent agreement. I and you could
Yes.
register a rent agreement. That doesn't mean we are married. So uh, it may be some other circumstance like the one I told you about, like a medical circumstance. That would possibly, supposing there are two people in a relationship and they have no other relatives. So
Yes.
no other person who could logically give consent. Then somebody who is in a stable relationship with the other partner and who has had a history of caring for that person should be in a position to grant medical consent.
Yes. Well, Mr. Hegde, now obviously there is the other thing that I wanted to ask you about is the directions that the court has given against discrimination. The Chief Justice of India has given against discrimination for the police, and the directions he's given to government in terms of education of people, creating hotlines, creating safe houses, things like that. This is obviously it's positive to note. These were instructions that have we've had heard in the past. How important are these directions right now? What sort of a change do you think they'll make?
They are very important directions in as much as they probably set the pattern for any anti-discrimination legislation that is to follow. By the way, it is not only the center that makes legislation. Individual states can also come up with legislation. And once there is a legislative exercise in place,
Yes.
then it would be for somebody else to challenge that legislation and go through the court process to strike it down. So sometimes it is said that a dissent is an appeal to the brooding spirit of the law, to the wisdom of a future day. So a lot
Yes.
of it when you write, especially in the Supreme Court, even if the majority is not with you at that moment, you are writing as a signpost for generations of lawyers and judges to come.
All right. Sanjay Hegde, thank you so much for explaining that to us and making that a lot clearer. Sanjay Hegde, senior advocate at the Supreme Court,
Thank
telling us that this is perhaps a signpost for the future. Even the directions given by the Chief Justice is actually forms a structure of non-discrimination in going forward. The members of the queer community, I beg your pardon, know what they should expect from their police and their government, and if these directions are violated, they have a structure on which they can go back to a court and appeal for justice. Thank you so much for staying with us through this whole day and taking your information from us at the Beetroot team. It has been our pleasure, to bring you all of this breakdown and to bring you all of this information, and we'll continue to bring you updates on this matter as and when we get them. Thank you for watching. For more news and updates, download the Beetroot News app from the App Store and the Play Store.